The point at which we are today, we've arrived here as a result of the fact that yesterday, almost throughout the entire sitting, the petitioner, through his lawyers, led by Mr. Chachuchikata, made an application to the court, and this application had to do with they being allowed to reopen their case following the decision taken by the second, at the first end, of course, the second respondents, not to present any witnesses. Indeed, many were those who expected, even at the very beginning of this hearing, that the chairperson of the Electoral Commission, Madam Jane Mensah, will mount the witness box. Indeed, we were also told, even by some members of the MPP, persons who are also loyal to the second respondent, that Mr. Peter McMenu will be mounting the witness box on behalf of the second respondent. And so it took everybody by surprise when the second as well as the first respondents both indicated that they were not willing to put any witness in the box, given the evidence given by the petitioner. They were not convinced that the burden of proof had been shifted from the petitioner onto the respondents. Now, following those decisions taken by the two respondents, the petitioner's lawyers then applied to the court to be allowed to reopen their case so they may be able to subpoena the chairperson of the EC. And in this case, the chairperson of the EC, per their arguments, is not a party to the suit. The EC is a party to the suit, but not its chairperson as a person. And so the subpoena, they want the chairperson as an individual to be subpoenaed to answer questions in the court. The arguments and debates and counter-arguments took place in court almost throughout the day until the court rose. And when the court rose, it indicated that it will convene again today to arrive at a decision. So we are in court basically to hear the decision that the judges will arrive at following the arguments they heard from both sides yesterday. And usually when the day sitting is over, we know that the first respondent does not make itself available for those press conferences. The petitioner and the second respondent's spokespersons, who usually speak to the media right after every day's sitting. And yesterday, both parties, and I'm talking about the petitioner and the second respondents, were very optimistic. They were upbeat that today's decision will go their way based on the arguments advanced by their lead counsels. It remains to be seen what impressions the judges make out of those arguments. Again, just to give you a background as to why we are here, for those who perhaps haven't been following this petition, on the 9th of December 2020, the chairperson of the EC made a declaration that may announce the president, Nana Addo Dankwa Akufo-Addo, as president-elect. Then, by the 10th of that same month, December, the EC had come with some press releases making some certain corrections to portions of the declaration. But effectively, the announcement was that the declaration, those corrections did not effectively affect the... of course, I have Mr. Gabriel Asare Dako. We'll call him Gabi. He's here. So I need 2 minutes of your time. And sorry. Mr. Gabi, so you are a lawyer, an interested party in this matter as well. Yesterday, we just want to break down the issues for the understanding of our viewers. So yesterday in court, the petitioner sought to seek the court's permission to reopen his case. You were opposed to that. Why?
Well, I think the reasons were pretty simple, in the sense that you brought the electoral commissioner and the winner of the elections to court. You've opened your case. You've called your witnesses. Even the petitioner himself didn't think it was necessary for himself to be in the box. He called witnesses, and the witnesses themselves, when you ask them questions about a petition and they don't like it, they can turn around and say, I'm not a petitioner. You said you were going to call 5, and eventually you ended up calling 3. And you closed your case. And right from the beginning, I think on the 20th of January, the respondents filed a motion, which is that it was a preliminary objection asking the court to dismiss the case summarily. What it meant was that they felt that there was no cause of action. So that should have given counsel for the petitioner a hint that right from the beginning, these guys don't think that you have a case. So it's difficult for you to rely on the fact that they could open their case and you have an opportunity to cross-examine them. That should have given him a hint. Right. And it didn't come on just because the court said that they will deal with that matter at the end of the trial. The preliminary objection, which was raised by the respondents, the court did not act on it, said that they will give their ruling on it at the end of the case. But that should have told you that really they don't think you have any cause of action for them to respond to. So they were not likely to exercise that right to elect to adduce evidence. So that really is the thing. And then when you tell us that you were relying on it, on an affidavit, what they said in an affidavit to an interlocutory application on your part, that when the opportunity comes, you can put these questions to them at cross-examination. I find it difficult because if you believe them, if you relied on it, then why did you file even a review? Well, I mean, of course.
But currently where we are at, it does appear the petitioner is seeking to use other routes to arrive at the same destination, the destination of cross-examining the chairperson of the EC. Now, the route is that the chairperson of the EC, as an individual, is not a party to this case and therefore can be subpoenaed to court.
Well, when you look at the Constitution, when it tells you about the Electoral Commission, it tells you that the Electoral Commission is comprised of what? The chairperson, 2 deputies, and I think 4 other commissioners. Okay? So essentially, even when you go into case law will tell you that you cannot, when you sue a corporate body, it is a person who is responsible for that corporate body that will come to court. So there's no way that we could have brought the whole Electoral Commission to court. It is the chairperson who represents, and that has been the practice. So I think trying to make that pedantic, sedentary of an argument that it is the person, but why is the person necessary? The person is necessary to you because he's the chairperson. She's the returning officer of the Electoral Commission. That's the only reason why she matters in this case. So you cannot try to then say that is the person that you want, because the person who is representing the Electoral Commission. So, well, let's wait and see.
Thank you very much. We hope to talk to you.
Your questions during the press conferences, excellent.
Thank you very much, and I hope to see you after that to ask you some of those questions as well, sir. That was Gabriel Asari-Wachudako, a member of the MPP. Is one of the very interested. That's Professor Jenana Opokwajiman, the running mate to the petitioner, Mr. John Dramani Mahama, in the 2020 elections. She has been in court from day one. You would recall that she happens to be the first female vice-chancellor of any university in the country. She was the vice-chancellor of the University of Cape Coast until she was appointed as Minister of Education under the administration of former President John Dramani Mahama, and she stepped up to become his running mate in the 2020 elections, the elections which currently is in controversy, which declaration is in controversy here at the Supreme Court so far. We are getting indications that the chairperson of the EC will soon arrive, Mrs. Jane Mensah, whose declaration of the results on the 9th of December is in contention right now. And most specifically, the controversy appears to be around her and not around the second respondent's witness as well, because indeed it's not only the first respondent, in this case the EC, who has indicated that it will not present a witness. The second respondents have also indicated so. It does appear that the petitioners are very much interested in getting the first respondent's witness, in this case Mrs. Jane Mensah, to be cross-examined, and not particularly so much interested in cross-examining Mr. McMenu. But it's also instructive to remind you that yesterday in court, the lead counsel for the petitioner did indicate to the court that he wanted a certain tape to be played, a tape in which Mr. McMenu, who is the witness for the second respondent in this case, was heard talking about some vote pardon, but of course the chairperson of the EC, Mrs. Jane Mensah, has arrived and going through some security procedures. Of course, she's here with her deputy commissioners. From day one, she's always been in court. She's here right now with her deputies. Of course, you see Dr. Bosman Asari is one of her deputies. Dr. Bosman Asari, once upon a time, was a lecturer at the Political Science Department of the University of Ghana until he was appointed one of the deputies of the EC when Madame Charlotte Sey's regime came to an end. You recall that there were some petitions against the Charlotte Sey-led EC, which led to the dissolution of that administration, upon which Mrs. Jane Mensah was appointed together with her other deputies ahead of elections 2020. Of course, before then they had also supervised district level elections. And you recall that there was also the issue of a referendum when Ghana had to vote as to whether or not we needed to create more regions. It was under the regime of Mrs. Jane Mensah and her deputies. But of course, we are in court today because the petitioner, Mr. John Dramani Mahama, is appealing to the court to nullify the results that were declared on the 9th of December, because according to him, none of the two leading candidates, in this case the petitioner himself and Mr. Nana Addo Dankwa Akufo-Addo, none of them attained the mandatory, constitutionally required 50% plus mark, more than 50% mark. None of them, according to the petitioner, attained this feat, this number that would indicate that you genuinely won an election, and that's what they have been trying to prove in court. And the case was filed on the 30th of December, given the constitutionally mandated time limit within which election petitions can be filed. But of course, there have been some significant changes since the last time there was an election petition in Ghana. In fact, the very first time in the history of the Fourth Republic that there was an election petition was in 2012, when Nana Addo Dankwa Akufo-Addo, Dr. Mahmoud Bawumia, as well as the late Jacob Ichebi Lamte, who were the petitioners at the time, came to court to seek the court to reverse the results that were declared after the 2012 elections, and declare Nana Addo Dankwa Akufo-Addo as winner of that election. Of course, we all know what happened. For 8 months, we were here at the Supreme Court for the panel to determine whether or not there was merit in the petition brought before it in 2013 for the 2012 elections. Of course, there have been very significant changes here. You realize that in this case the petitioner is just one, and that's because since 2012 different constitutional instruments have been introduced and nullifying, so to speak, some of the earlier constitutional instruments. We are currently operating under CI 99, which specifically speaks to election petitions and how they should be organized, and all the other issues around election petitions in the country. One of those is the fact that it is just one person who can petition, unlike in 2012 when we had 3 petitioners. That's number one. Then number two, you'll recall that in 2013, when the 2012 election petition was being heard, the petitioners actually sued, called 2 respondents, in this case the EC and Mr. John Dramani Mahama, in 2012. But the NDC then said they were an interested party in this suit because the candidate John Dramani Mahama had become candidate on the ticket of the NDC, and therefore if the NDC at the time was the John Dramani Mahama was being sued at the time, then it was only sorry, so I'll come to that point later, but I've just been joined by one of the lead spokespersons for the petitioners' lawyers, Mr. Tamaklo Edwiji. Thank you very much, sir. So we realized that you applied to the court to be allowed to reopen your case. We are in court today, but for those of our listeners who still are confused as to what this is all about, what you are hoping to do, for the layperson out there, it's like you did not prepare adequately before coming. Now you've come to court, you've heard arguments from the respondents, you want to go back and now prepare to come and face them. Is that the case?
Absolutely no. That cannot be the case. The truth of the matter is that at the time we were closing our case, the Electoral Commission chairperson had put before the court a witness statement and has served us a copy. The second respondent had, through his witness, Peter McMahon, filed a witness statement and has served us. So as at the time we were closing our case, one, the chairperson had deposed to an affidavit when we came for a review in respect of the interrogatories. The affidavit in opposition was deposed to by the chairperson, whereupon she indicated that she will be taking the stand, and that when we get to that point, the 12 questions that we're asking, we could put it through her. If you recall, one of the justices actually asked Mr. Chikata that is it his case that those questions cannot be asked during cross-examination. Yes. So at all times we were prepared, except to say that we were taken when after we said we have closed our case, only for the lawyers for the first and second respondent to now say that even the witness statement that they have filed, they do not intend to rely on it.
So you have not been able to prove your case at the time you were closing your case?
No, we have.
If you had, then why the insistence to have the first respondent's witness?
I think that there's a certain misconception that as at the time you are closing your case, it should be the case that, oh, you had finished. Remember that our allegation is that the returning officer of the 2020 presidential election misreturned the election. She misreturned the election to the extent that, one, there were issues of vote pardon. That has not been denied. Two, as we speak, there is one CI 135, which is the presidential declaration instrument, which has been gazetted. Under cross-examination, the second respondent lawyer actually said, quote, manifestly erroneous, the declaration on the 9th. If something is manifestly erroneous, what does it mean? Has there been any other declaration save the 9th one? So these are the issues.
Okay, so we know about a declaration on the 9th, but subsequently we also saw and read and indeed published press statements from the EC indicating corrections of certain minor errors, so to speak.
No. Has there been any other gazette? Has there been any other instrument? Unless, of course, you are telling me that you can use a press release to amend a constitutional instrument. It's never done. It's never done. So these are the issues.
All right, so we often do not want to preempt what the court will say, but we know that a decision will be taken today, and we hope to speak to you right after the decision. And that was Mr. Tamaklo Eduji, one of the spokespersons for the legal team of the petitioner. And it's just about time. We'll be going over to the courtroom soon. Mr. Abraham Amaliba is one of the legal team members of the petitioner. He's also just arrived in court, and when you see people arriving in droves around this time in court, then it indicates that even the judges are ready, and probably in the next few minutes will be making their presence in the courtroom for us to hear their ruling. So basically, today, unless something else comes up, we basically expect that the ruling, the decision that the court has arrived at, will be read to the public, to the petitioners' lawyers, as well as the respondents and their lawyers as well. And after that, the court will then indicate what steps to take next. It's instructive to remind you that earlier, late last week, the court did indicate that all parties should present their written addresses by close of day on Wednesday, 17th of February, which is just tomorrow, so the court could reconvene on the 18th. Now that the petitioner has made an application, and now that the application has been heard, which was tomorrow, and now that we are expecting a ruling, it remains unclear what then becomes of the written addresses. Indeed, yesterday in court, Mr. Akoto Ampao did indicate that they would proceed. The respondents, at least the second respondent, would proceed to present its written address. However, he presented a concern also. That the concern was that the petitioners must not be allowed to see their address, no matter what the circumstances are. The court assured them that that would exactly be guaranteed. But so then it remains to be seen what then becomes of the written statements if the wishes of the petitioner are granted today. But if the wishes of the petitioner are also not granted today, what are the steps that the court will then take next? Those are issues that remain unclear for now. As soon as we grab any of that information, surely we will make it available to you. Now, earlier we're trying to bring you an analysis and a comparison of 2012 petition and the petition of 2020 and some of the differences. We arrived at that point where I was telling you about the fact that in 2012 Okay, so I'm getting indications that the courtroom is almost ready, and we have to move in there so that the ruling can be heard. But of course, we'll go to the studio now where Morris and George Sappho have been engaging other persons, experts out there, to further break down the issues. Then we'll return to court and hear the ruling. After that, we'll by all means be back here to break it all down for you.
All right, thank you very much, Abdul Hai Mumin. And whilst we wait for the justices to take their seats, we'll go for a quick commercial break. We'll be right back. Stay with us.
When you need a shoulder to cry, run on my pumping, so we try was suicide.
2020 election petition hearing. We're still here in studio. Earlier on, our colleague Abdul Momen spoke to some spokespersons, both for the respondent and the petitioners. So he spoke to Gabi Ochidako and Edujit Tamaklo, who is a spokesperson for the petitioners. We still have on the line Dr. Ajiman Budu, who has been helping us understand this particular case in simple terms. We are live on Ghana Television and on GBC News. You're also live on Unique FM and on Facebook at Ghana Broadcasting Corporation. Doc, are you there?
Yes, I'm here, Morris.
All right, so there was this issue of you can subpoena a person and not a party. Can you help us understand this and how that relates in this particular case?
All right, before we get to that point, I'm getting information, or there's information to the effect that a letter was written by counsel for the petitioner to the address to the Chief Justice of the Republic of Ghana, setting out a number of things that they wanted the Honorable Chief Justice to consider before today's ruling. And so I believe that that's why there's a bit of a delay before the court actually sits. I'm hearing that the court will sit in about 30 minutes time or so, and this information was it's out there on other media platforms.
Sure.
That there was a letter to the effect that had to do with the proceedings yesterday, that one of the justices talked about the fact that, or asked the question whether the ruling of the court on the objections earlier on in relation to the closing of the case of the respondents, whether that was not a bar,
a judicial
to
bar,
the petitioner trying to reopen their case to subpoena the electoral commissioner. And I believe that the letter basically suggests that counsel for the petitioner wants to be heard on those arguments, or wants to argue those points before the court considers its ruling. I mean, this information is coming from sources within the precinct of the Supreme Court, other media personnel who are there. And I believe that's probably what's causing this delay. And so I just felt that we need to put it out there so that people are aware of what is actually happening.
Sure.
And
but is it a practice that you can apply to be heard on some of the comments that the justices make? Is that a practice?
The practice that what? I didn't quite get the question.
I mean, what they are seeking to do, specifically to address what, I mean, the comments that one of the justices made, is that a practice? Are they allowed to do so?
I mean, throughout the proceedings of the court, or throughout proceedings in this particular petition, or the hearing of this particular petition, we've seen that whenever there's an application before the court, counsel who is moving that particular motion or has brought that particular application is allowed to argue his point out, or move the motion and then make his arguments in support of that particular application. And then the respondents are also given an opportunity to respond to those specific arguments. And sometimes counsel for the petitioner is given leave once again to respond to the response that have been given by the respondents. And then once all is done and once he rests, then the court will decide maybe to ask further questions or to adjourn to consider their ruling and then give their ruling back. So that's usually the process that ensues before the courts generally. And I mean, this not being a motion before the court is simply a letter. That's the information that we're getting. That's if the information is true. Right. That it is a letter addressed to the Chief Justice of the Supreme Court of Ghana, the Chief Justice of Ghana, basically suggesting that they wanted to argue some points or something of that sort. That is not necessarily how the procedure is, like I've explained, and we've all been witness to in these proceedings, that once the arguments come to a close, that is it, and the court will deliver its ruling. But of course, the Supreme Court is the Supreme Court. It is the highest court in Ghana, and they can, depending on the exigencies of the circumstances, they can take decisions and do take decisions that, in their opinion, are just in terms of the case or matter. Because remember, at the end of the day, the main reason why the court is sitting and hearing the petition is to deliver justice. And so when they believe that the justice of the case so demands, they may make certain orders or give certain directions that they deem fit to properly dispose of the matter.
All right, so now you want to answer my question.
Yes, and your question had to do with subpoenas, and what was the first part of the question again?
So you can only subpoena a person and not a party in a civil case. So counsel for the petitioner, in response to the response that had been given by the respondents, both the first and second respondents, essentially suggested or was suggesting that the Electoral Commission, or the first respondents, had chosen not to adduce evidence, and the first respondent, being the Electoral Commission itself, choosing not to adduce evidence has no bearing whatsoever on the compellability of the chairperson of the Electoral Commission. So he tries to draw a distinction between the first respondent, which is the Electoral Commission, and the chairperson of the Electoral Commission, which is Mrs. Jean Adukwe Mensah. So that was a distinction that he was trying to draw, especially in response to a statement, I believe, that was in the affidavit in opposition to their application to reopen their case, where essentially the deponent was suggesting that because the first respondent had been essentially been affirmed in their decision not to testify or not to adduce any evidence, she was also barred from essentially adducing evidence. And I'm just trying to summarize what that particular paragraph stated, not that those were the specific words. But we also know that the Electoral Commission chairperson throughout these proceedings has been announced as the one representing the first respondent, that is the Electoral Commission. Sure. And I believe that was one of the things that the court went into. And if you remember, the Honorable Chief Justice read a portion of their earlier ruling which talked about the fact that the party, which was the Electoral Commission, could not be compelled to adduce any evidence, meaning they could not be compelled to call witnesses to testify on their behalf, regardless of the fact that they had filed a witness statement, which was the witness statement of the chairperson of the Electoral Commission, Mrs. Jean Adukwe Mensah. So basically what the petitioner was saying in his arguments before the court yesterday was that there was a fundamental distinction between the Electoral Commission as an entity and the Electoral Commission's chairperson in the person of Mrs. Jean Adukwe Mensah. So to the extent, even though that the Electoral Commission cannot be compelled to adduce evidence, for instance, the court cannot compel the Electoral Commission to by all means call Mrs. Jean Mensah to provide testimony. The petitioner was essentially suggesting that if they were given leave to open or reopen their case, could cause a subpoena to be issued to compel the chairperson of the Electoral Commissioner, who is quite distinct from the Electoral Commission, to actually testify before court. Right. That was the distinction that was being made. Did you say she's quite distinct from the Electoral Commission? So we want
I'm just summarizing the argument that was being made by the petitioner.
Right.
That the chairperson, as a matter of fact, the Electoral Commissioner is not necessarily the Electoral Commission. If you look at the Constitution, Article 43(1), it talks about the fact that there shall be an Electoral Commission which shall consist of A, a chairman, B, two deputy chairmen, and C, 4 other members. So the Electoral Commission, the commission itself, is comprised of not just the electoral commissioner, but 2 deputy chairmen and as well as 4 other members, making 7 members of the electoral commission.
So in this case, there's a distinction between the person of Jane Adukwe Mensah and the electoral commission.
That is the argument that the petitioner sought to make. But the counter-argument, which I believe was made to some extent, was that, and even by reading the affidavit in the position, for instance, of the first respondent, seems to suggest that, and it's clear that right from the beginning, you know, when the parties are called, we see that the petitioner is called and maybe Mr. Johnson Asiedu Ketia is representing the petitioner. First respondent is called and Mrs. Jean Adukwe Mensah is the one representing the Electoral Commission. Then the second respondent is called and Mr. Peter McMenu is the one representing the second respondent. So at all material times, Mrs. Jean Mensah, who is the chairperson of the Electoral Commission, has been representing the Electoral Commission in these proceedings. And of course, the Electoral Commission, it being the first respondent, you cannot necessarily bring the commission as an entity. The commission is represented by individuals, being a corporate entity or being a body corporate. So that is why the chairperson is representing the Electoral Commission. So to that extent, or to the extent that the chairperson of the Electoral Commission is representing the Electoral Commission, then it seems as though their interests align one way or the other. That is a sort of counter-argument to the point that they are distinct, because you can see clearly that the Electoral Commission chairperson is a member of the Electoral Commission. But obviously, these are arguments that are before the court or have been made to the court, and we believe that the Supreme Court will give its ruling on the issue and bring the matter to an end.
Right. So the petitioners have given indication that they will subpoena her to appear as an adverse witness. Is there any difference in cross-examining an adverse witness from cross-examining a witness who voluntarily mounts the box? Does she have any immunity? Can she appear and say, I don't want to speak or something?
So an adverse witness, and I believe we talked a little bit about this yesterday, but we weren't able to.
Sure.
An adverse witness simply can either be an unfavorable witness or a hostile witness, as it was referred to at common law. An unfavorable witness is simply a witness that may tell the truth or will tell the truth, but may not necessarily inure to the benefit of the party that calls that witness. A hostile witness, on the other hand, is a witness who may be hostile, for want of a better word, a witness who may not necessarily comply with what you seek to do, or may decide not to answer or be obstructive and things to that effect. And we know, for instance, that in Ghana, we refer to such witnesses as adverse witnesses, because if you look at Section 72 of the Evidence Act, NRCD 323, it talks about the fact that the court can exercise its discretion in a civil matter, either on its own motion or on the application of a party, to call a witness whose interest may be adverse to the party calling that particular witness. And so it is possible that you would have an adverse witness. And when you have an adverse witness, one of the things, and that goes to the question that you are asking, that what's the difference between, say, cross-examine an adverse witness to a regular or normal witness. So, for instance, you will be able to, you need to obviously seek the leave of the court to be able to treat that witness as an adverse witness. So you may ask leading questions. And leading questions are simply questions which preempt the answer, or questions that you already know what the answer to, or preempt the answer by virtue of the question itself. Another consequence of treating a witness as an adverse one is that the credibility of the witness or any part of his or her testimony may be attacked. So you can seek to impeach the character of that witness, because essentially once an adverse witness is called, there's no examination in chief, for instance. Once the adverse witness is called, straight away, the party calling that witness and seeking leave or having been granted leave to treat that witness as an adverse witness will be engaging in cross-examination. And so that is where, usually there would have been the examination in chief or the witness statement of that person would have been adopted. But for an adverse witness, we go straight into cross-examination at that particular point in relation to that adverse witness.
Doc, the adverse witness, can he or she also have a lawyer, or in this case, the first respondent can also represent the adverse witness?
So what the rules or the law provide, that once an adverse witness or a witness is called and that witness is treated or leave has been granted to treat that witness as an adverse witness, the other parties are also entitled to re-examination. And we know that re-examination usually takes place after cross-examination, which gives an opportunity usually or normally for the party that has called that witness to be able to also clarify certain statements or seek to close any holes that may have been opened during cross-examination in the testimony of that witness. So what will happen is that once the adverse witness is cross-examined by the party that has called that witness, the other parties in the case will also have the opportunity to also ask questions of that adverse witness by way of re-examination. So it will be treated as though it was re-examination of those parties. The court may also ask questions of the adverse witness as well.
So at the point where the adverse witness mounts the dock, in this case, she will cease to be the witness of the respondent, right?
The respondents in this case have no witnesses. We know already that they filed witness statements or they filed a witness statement but chose not to call that person to give testimony and closed their case. So they have at this point no witnesses in this case. So, and I don't want to preempt anything that's going to happen, so I'll stay away from specifics. Assuming in a civil case that a plaintiff has closed their case, the defendant has also closed their case, and the plaintiff seeks the leave of the court to reopen their case, for instance, to recall a witness, because that's one of the things that can be done. You may recall a witness. The court even is given power to recall witnesses if it deems it fit and right, or the justice of the case so demands. They can recall a witness to examine that witness again if there's some pertinent information or clarification that the court seeks. The same way, a party may also seek to, for instance, reopen their case to recall a witness. And I gave a specific example the other time, which is premised on Order 38, Rule 3E5 of CI 87, the High Court Civil Procedure Amendment Rules, CI 87. And what that order provides is that it is possible that a party may have filed a witness statement in a case, but then choose not to call that witness to adduce evidence before the court. In that situation, any other party to the suit before the court may also then seek to introduce that witness statement of that party, even though the witness statement is not yet in evidence and as a result can not be relied on as evidence. The rule provides that the other party may introduce that witness statement as hearsay evidence. Right. And they may do so, for instance, by recalling one of their witnesses so as to tender that witness statement to that particular witness. It's a possibility that can happen. So in a civil case of such nature, where a plaintiff seeks to reopen their case, they may do that. They may reopen their case for the specific purpose of, say, tendering in that witness statement, or may reopen their case to also seek the leave of the court to, for instance, compel some person to come and testify. And obviously, these are all discretionary matters that the court decides on the basis of the merits of the application before it.
All right. All right, Doc, we'll go for a quick break. Just stay with us. We'll be right back. We're going for a quick break, and we're still waiting for the justice to get back so as for the ruling. But before that, let's go for a quick break. We'll be back, yes. We'll be right back.
All right, so welcome back. We're still waiting for the justices to make the appearance at the Supreme Court, and we'll hand you over to the Supreme Court as and when we get indications that the justices have arrived. We hear there has been a short delay due to a letter that the petitioners have written to the Chief Justice to hear them on a particular case which has to do with one of the statements that one of the justices made. In effect, she was saying that the ruling that they made on the 10th of February upholding the decision of the respondents not to present a witness to adduce evidence, some way, somehow, presents a judicial bar to what the petitioners are seeking to do now. That is, trying to open their case and subpoena the Electoral Commissioner to appear in the witness box at all costs. We still have via Zoom Dr. Kweku Ajiman-Budu. He's a law lecturer. He's a lawyer first, a law lecturer, and head of Law Center's Gimpa Faculty of Law. Good to have you join us once again, Doc.
Yeah, yes, thank you.
All right, Doc, before we went for the break, we were talking about the adverse witness, and you said that the adverse witness will be re-examined by the other counsels or the respondents. Now, if the respondents don't have a witness, how are they going to re-examine? I mean, emphasis on the word re-examination, understanding what re-examination is also about.
No, so the point is that at the point where a plaintiff has, for instance, has applied to the court to seek leave to treat a witness as an adverse witness, at that particular point in time, that witness is examined as though the witness is being cross-examined. The witness is examined as though he or she is being cross-examined. And so once the party that calls the adverse witness, you know, under normal circumstances, you would call a witness who will be testifying to help establish your case. But it is possible sometimes that a witness that may help your case in some way may not necessarily want to testify or may be obstructive one way or the other. And that's why the law provides this idea that a witness may be treated as an adverse witness. So the interest of that witness may not necessarily be in line with yours. In actual fact, it may be adverse to your interest, you, the party calling that particular witness. So under those circumstances, the witness is not made to testify in chief or give his give his evidence, testimony, the evidence in chief, or even file any witness statement. That person is treated right from the onset when he or she is called as an adverse witness, if the court grants the leave for you to treat that person as an adverse witness. So once you are done with that cross-examination, because you called the party and the party was treated as an adverse witness, one whose interest was adverse to yours, your opponent or the party on the other side or the other parties in the suit will also be given an opportunity to re-examine that adverse witness. And so it's only just fair, it's part of the fairness of the court processes and procedures that when a party is cross-examined as an adverse witness, the other party is given an opportunity to re-examine that witness as well.
And this time around, the adverse witness, is the adverse witness allowed to have his or her own lawyer to represent her also in court?
It's not a question of having your lawyer represent you or not. It's as though it's similar to, for instance, when the court calls a court expert to an expert witness to give testimony in a trial, because there may be issues in play that are technical that requires an expert. So, for instance, if the issues that needs to be resolved has to do with structural engineering, for instance, or mechanical engineering, and the issues are that complicated, a court expert or an expert witness may be called by the courts to give testimony that will help the court arrive at a conclusion, a just conclusion. It is in the same vein that if a witness is treated as an adverse one, the other party has the opportunity to also examine that witness. And even before that point, it's even possible that you, the party calling a witness, and usually witnesses that you call have to or will usually be called to help you establish your case, to give testimony that will make the existence of the facts that you are alleging more probable than not in a civil case, which may lead to the release that you're seeking being granted. It is possible that a witness you may call may turn out to be an unfavorable witness because, for instance, the testimony of the witness that you feel he would give may be to support your case, but he may come there and be telling the truth all right, but may tell it in a way that is not necessarily in support of your case. And that is what is usually referred to as an unfavorable witness. So even though you called him yourself, it turns out to be unfavorable to your case. So these are things that happen or can happen during trials or during hearings, especially within the context of civil cases, but also it could happen in criminal cases as well.
All right, so it would be a gamble if you called an adverse witness. I mean, you will be gambling if you do that.
It's a gamble calling any witness at all, because like I'm saying, a witness, remember, we said before that the Evidence Act clearly provides that a witness needs to, the only way in which you can testify, generally speaking, is that you must have personal knowledge of the matters that you're testifying about.
All right.
So the witness is the only one that has, obviously there are exceptions because there's hearsay and all that, which is second-hand testimony, not necessarily first-hand. So you may call a witness that has first-hand knowledge of the matters to which he or she is testifying, but the testimony the witness gives may end up not supporting the claims that you are making. So it is a gamble one way or the other when you're calling witnesses, because at the end of the day, regardless of the facts that you are alleging and regardless of the relief that you are seeking, you need to be able to establish by evidence what you are seeking the court to agree with you on and to grant you your reliefs. And the testimony of the witness as well as the evidence provided by witnesses are key. And so it is possible that your witness may not necessarily help you establish your case. It's a gamble that you take because the court needs the truth to arrive at the conclusion. And it is the witnesses who have personal knowledge of the matters to which they testify that would be called. So if the person turns out to be unfavorable, and it happens sometimes that you know what the witness is going to say, but he comes to court and starts saying something totally different from what you thought that person was going to say, then you realize that the witness is either an unfavorable witness or is an adverse witness, and you may seek the indulgence of the court to treat that person as an adverse witness.
All right. So the 10th of February ruling, which ruling upheld the respondent's motion not to adduce evidence. But before we do that, I've just realized that the lead counsels in this particular case have been the ones who have been doing all the talking from day one. This is just engaging my mind. Under which circumstance would, say, Chachu or Akoto Ampao, say today I'm not coming to court, and so let's say Tony Lita should take over?
I mean, it's possible. I mean, we are all humans, and it may be possible that, for instance, a lawyer in a case may not be feeling well, and so may ask his learned colleague or learned friend to hold brief for him in court. It's very possible that may happen, and so it's not something that is out of the ordinary or strange for that matter in court proceedings. It happens sometimes. There are numerous reasons why counsel may not be available And so sometimes you inform the court, if there's enough time, you may inform the court ahead of time that you may not necessarily be available. For instance, it's possible that you may have two cases that have been scheduled around the same time, one in two different courts altogether. And since it's not possible for you to be at those two courts at the same time, you may ask a learned friend to hold brief for you, or you may seek to, and he may seek to have the case stood down for a bit so that other cases may be dealt with, and then subsequently, when you come, you may conduct your own case. Or if he is apprised of the case and, for instance, works with you in your chambers or works on that particular case and thus is authorized to deal with the case, he may decide, or it may be decided that he can continue with the case on your behalf at that particular point in time. So it's not, and you may be sick. It's possible that you're sick and you can't physically attend court, and so somebody needs to hold brief for you. So these are things that happen. These are ordinary and normal things that happen. Even in our workplaces, sometimes you may be sick and you will not go to work or get sick leave or take a day off and things of that sort. Lawyers are no different than any other person.
Okay, so let's talk about that ruling that I earlier referred to. My understanding was that at that particular point where the respondents said they were not going to allow their witness to mount the box, the Supreme Court, granted them that at that particular point and said we cannot compel the witness to mount the box. Does it bring conclusivity to the issue, and that even after that ruling, there is no point in time that maybe a circumstance may arrive where there will be the need for the respondents to allow their witness to mount the box?
So if I get your question right, you are basically trying to, or asking whether it is possible for a witness. I didn't quite hear the last part of your question.
I was just asking whether that particular ruling brought finality, and so after that ruling, there was no way that the EC chair could, mount the box.
To answer that question, we need to understand what that ruling was in relation to. The ruling had to do with an objection that had been raised by counsel for the petitioner in relation to the first respondent and then subsequently the second respondent choosing not to adduce evidence and therefore closing their case. The petitioner was objecting that they could not do that, and that by virtue of the fact that the first respondent in particular had caused the witness statement to be filed and served on the parties involved in the case, they had elected at that point to adduce evidence, and they could not renege on that election. So the ruling had to do with whether or not, indeed, by virtue of the filing of a witness statement, a party is compelled at all costs to call that witness to give testimony. And what the Supreme Court said in its ruling was that on the basis of Order 38 Rule 3E5 of CI 87, the High Court Civil Procedure Amendment Rules of 2014, it was possible that a party that had filed a witness statement may choose not to call that witness to testify. And we know that the witness statement is not evidence until you have called the party making the witness statement, sworn the oath, and the statement adopted as that person's evidence in chief. Until that point, the witness statement is simply a witness statement and it is not in evidence. And so Order 38 Rule 3E5 gives latitude to a party to decide that, yes, I have filed a witness statement, but no, I am not going to call the witness to give any testimony, for instance, because on the basis of the evidence I have heard so far, there's no case that has been made out in the first place for me to even waste my time to call any witness to adduce any evidence on my behalf, and that the court should decide the case on the basis of the evidence they have before it, which generally would have come from the plaintiff at that particular point in time. So that is the context of the ruling. It specifically had to do with whether you can compel a party to call a witness at all costs simply because they have filed a witness statement. And the court held that the law was settled, that a party will not be compelled to enter the witness box and testify in support of his or her case, and that it was a risk that parties who decline to give evidence take, knowingly or knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. That is the ruling of the court, and that is the context within which the ruling was given, specifically to whether when a party has closed this case, it must be compelled or it can be compelled to call a witness to testify on that party's behalf,
right,
simply because they have filed a witness statement. The issue now before the court doesn't have to do necessarily with that, because the court has given its ruling on that. The issue before the court now is that the petitioner is seeking the leave of the court to reopen its case. And then they, the petitioner, on the basis of the motion that they filed, want to compel the EC chairperson to testify. So it doesn't have to do with the other party being compelled to produce a witness to testify. It has to do with the petitioner in this case, or a plaintiff in a civil case, requesting to reopen their case for them to be able to subpoena a witness to testify in the matter. I hope the distinction is clear.
Very clear.
And
very clear.
Isn't the same witness we are talking about here with the earlier ruling and with this subpoena that might or might not actually be heard? Isn't it the same witness we are talking about?
Basically, it's the same person.
Okay.
It's the same person that essentially was the subject matter of the initial ruling. But the fundamental distinction was that this person was supposed to be a witness for the first respondent. And the application or the objection by the petitioner was that the first respondent was stopped because of the election they had made, and that the first respondent must necessarily call the EC chairperson to testify. What is being argued here is not the same thing. What is being argued here is that the petitioner, upon closing their case and upon the fact that the Supreme Court has ruled that they cannot compel a party to adduce evidence by way of calling a witness, the petitioner now is seeking to reopen their case so that they, the petitioner, can then call that person by way of a subpoena to testify. That is the fundamental distinction between the two.
So it does not present a judicial bar, does it?
All right. Before we go into that one, let's go to the Supreme Court now. They are just about taking their seats. We'll be right back. Over to the Supreme Court.
Writ number J1/5/2021. John Dramani Mahama. This is Electoral Commission of Ghana. Nana Ado Dankwa Akufo-Addo. Please, who is representing the petitioner? Samuel Ofosu Ampofu, my lords, represent the petitioner. Lords, Jane Mensah, chairperson, is representing the first respondent. Mr. Peter McNunu is representing the second respondent, my lords.
If your lordships please, I appear for the petitioner and with me my learned friend Tony Litha.
May it please my lords, Justin Amenuvo appears for the first respondent. With me, Alexander Samoa Samoa.
If it pleases your lordships, Akotuampa for the second respondent. My lords, with me are my learned friends Frank Davis and Kwekwe Rifi.
My lords, at the end, excuse me, sir. I'm sorry.
Yes, excuse me. Please accept our apology for the delay in today's proceedings. We try as best as we can to be very, very punctual. We had the problems with the running out of the room, so thank you very much. Yes.
My lords, at the close, right at the close of yesterday, when I sought leave to respond to counsel for the respondent's submission, a question came from the bench in respect of whether, based on your ruling that you delivered on the 11th, whether the position that I was taking could hold. And I believe your lordship read a passage of your ruling at that point. My lords, we have respectfully sought your permission to have that matter fully argued, because it really came right at the end of the proceedings yesterday. And we believe that in the interest of justice, it will be appropriate that that important legal matter should be aired fully. And we have attached to our letter to your lordships, we have attached some of the authorities that we intend to rely upon in order to make clear that the position that we have taken, or that we are taking in respect of that point that was raised, is the legally accurate position. And we believe that it will be in the interest of justice that we all be given a chance to make arguments on the matter.
Counsel, with due respect, it's a legal point, and we've taken notice of it. Yes. So don't worry. It is a legal point which the authorities have been cited. You certainly look at it. This is the ruling of the court. When the petitioner in this case closed his case with the testimony of his third and last witness, Mr. Robert Joseph Martinu, on the 8th of February 2021, the court, as our procedural rules and trials provide, called on the first respondent to open his defense by the calling of his witness, whose witness statement had already been filed on the orders of the court. This witness happened to be the chairperson of the first respondent, Mrs. Jane Adokwe Mensah. Counsel for the first respondent told the court that he had weighed or scrutinized the case of the petitioner as presented by three witnesses, and in his view, the petitioner had not provided any substantial evidence in proof of his case, for which the first respondent had to mount the witness box to testify in answer. The first respondent therefore prayed the court to determine the petition on the oral testimonies and data presented by the petitioner through his witness and decide the main issue at stake, which is whether or not none of the 12 presidential candidates who contested the 7th December 2020 presidential elections did obtain more than 50% of the valid votes cast in the said elections. The second respondent, who was declared as winner of the elections by the first respondent, whose declaration ignited the filing of the instant petition, associated himself with the first respondent on his prayer and told the court he also did not desire to give any testimony through his attorney as contemplated. According to him, the petitioner did not discharge the burden imposed on him by law to produce sufficient evidence to buttress his case, so there was no need for him to say anything in explanation. He supported first respondent prayer that the court should resolve the petition on petitioner's evidence only, since the burden was on him to prove the reliefs he is seeking. This position of the respondents to close their case without adducing any evidence at all, which the law permits them to do, did not go down well with the petitioner. Counsel for the petitioner resisted this position of the respondents and prayed the court to compel the first respondent chairperson specifically to testify as first respondent witness, since he had filed a witness statement to that effect and therefore had elected to testify. As for the second respondent, petitioner said he was not bothered about his refusal to testify. The court adjourned for the parties to submit legal arguments for its determination of the matter, which they did. On the 11th of February 2021, the court dismissed the petitioner's objection to the respondent's decision not to testify and gave reasons in the written ruling delivered for that purpose. One of the reasons given by the court in dismissing the objection of the petitioner was that this court could not compel the first respondent to call its chairperson as its witness, as Rule 3E, Subgroup 5 of Order 38 of the High Court Civil Procedure, Rule CR 47 as amended by CR 87 permits them to do so. Immediately after the court's ruling on the issue, the petitioner filed the instant application. It was filed on the same 11th February 2021 and almost around the same time that this court delivered its ruling, dismissing petitioner's objection to the closure of respondent case. There is no doubt that the instant motion was triggered by the ruling of this court, in which the court endorsed the respondent's prayer not to volunteer any evidence whatsoever. The petitioner did not hide his feelings and expressed it lucidly under paragraph 15, 16, and 17 of his affidavit in support of the application as follows. Quote, 15. As a result of the ruling of the court of Thursday, 11 February 2021, it has become necessary, I am advised and very believe, that my counsel use the subpoena powers of the court under Order 38 Rule 10 of CR 47 to compel the attendance of the chairperson of first respondent to appear and testify in court. 16. At the time my counsel closed my case, the representation that had been made by each respondent to the court, and specifically to me, was that witnesses who had filed witness statements were going to testify. It therefore came as a surprise that both counsel for respondents announced on Monday, 8 February 2021, that this was no longer the case. 17. My counsel is seeking leave of the court to reopen my case to enable the subpoena referred to above to be served on Mrs. Jane Adukwe-Mensah, so she can appear before the court to testify. End of quote. The application is headed Motion on Notice for Leave to Reopen Case of Petitioner to enable Chairperson of Electoral Commission to testify. From all indications, the target of the petitioner in this application is not the second respondent, who has also filed a witness statement through an attorney, but the chairperson of the first respondent. The application, which is not known under our rules of procedure, has been brought under our inherent jurisdiction as contended by counsel for the petitioner. According to petitioner, he is praying the court to reopen his case, which this court had declared closed on his own instructions, to enable him subpoena the chairperson of the first respondent to testify as a hostile or adverse witness. The petitioner advanced almost the same argument he made before the court during his objection to the closure of the respondent case. The respondents have strongly opposed the application and have cited both local and foreign judicial decisions to support their arguments. Legal counsel for the petitioner urged on the court that he wanted the chairperson of the first respondent to testify as an adverse witness of the petitioner. Counsel also made references to paragraphs 31, 32, and 33 of the affidavit in support of the application as to why he wanted the chairperson of the first respondent to testify. The other point petitioner's lawyer kept urging on the court was that the chairperson performs an important constitutional duty and must be made to account to the people for her stewardship and to vindicate herself. The question is, how can the chairperson of first respondent vindicate herself when he is not on trial before us? He was neither being personally sued nor arraigned before this court on any complaint or accusation, civil or criminal, for which he was to explain or account to anybody for anything he has done or not done. It is the institution, the Electoral Commission, which he has, that has been accused by petitioner of not having performed its constitutional duty according to law. That the petitioner need the personal testimony of the chairperson of the institution sued before he could prove or establish the alleged non-performance of his constitutional duty by the first respondent. We do not think so. What indeed baffles this court is the intimation by counsel for the petitioner that he intends to call the chairperson of first respondent as an adverse witness. Black's Law Dictionary, 9th edition, edited by Brian A. Garner, defined a hostile witness as, quote, a witness who is biased against the examining party, who is unwilling to testify, and who is identified with an adverse party, also termed adverse witness, end of quote. A hostile or adverse witness, as the definition shows, as we understand the term in practice, is therefore a witness who has been called by a party to testify in support of his or her case and who, whilst in the witness box under examination in chief, performs hostile and gives evidence contrary to the party who called him and in support of the opponent's case. The party in such circumstances can apply to the court to treat such a witness who is already in the witness box as a hostile or adverse witness. This would enable the party calling him to cross-examine him as if he is a witness of his opponent to solicit the truth in respect of the issue at stake. A witness who has not yet entered the witness box to testify cannot therefore be called an adverse or hostile witness under any circumstances. The court exercises its inherent jurisdiction inter alia to correct errors in procedure and to ensure that no miscarriage of justice is occasioned during a trial. Inherent jurisdiction, which is also referred to as the inherent powers doctrine, is the principle that allows courts to deal with various matters over which they have intrinsic authority. The petitioner has not demonstrated to us in any way that the decision of the respondent not to testify, which was upheld by this court in its ruling of 11 February 2021, has occasioned him any miscarriage of justice. That decision is backed by law, particularly our rules of procedure, case law, and settled practice. We demonstrated this in our ruling of 11 February 2021 when we rejected petitioner's objection to the respondent's decision not to testify. At the time this application was filed, petitioner had expressly closed his case, likewise the respondents. He is therefore seeking our discretion to reopen his case and to lead further evidence, which evidence he never disclosed to the court. He is not entitled to his prayer as of right. It is subject to our discretion, and before we can exercise our discretion in his favor, we must satisfy certain basic conditions as laid down by case law. The general expectation imposed on all litigating parties is to place the whole of their case before the court at the time of the hearing. The process of invoking the inherent jurisdiction of the court at the close of the case of the party to reopen a closed case in order to adduce fresh or further evidence is thus a necessary step which the importance of finality of litigation fronts upon, save the presence of exceptional circumstances. In the Canadian case of Oakley versus Royal Bank of Canada, 2013 ONSC 145, 2013 OJ number 109, Supreme Court, Andrew J. held, quote, the court requires the parties to litigation to bring forward their whole case in both civil and criminal matters. The Crown or plaintiff must produce and enter in its own case all clearly relevant evidence it has. On the other hand, a trial judge has the discretion to permit a party to reopen its case. This discretion, however, must be exercised judicially. It must involve a scrupulous balancing of the accountability of counsel for decisions regarding the prosecution of his case and the interest of justice. End of quote. Though this Canadian case is not binding on us, it has a persuasive effect as it espouses the principles governing reopening of closed case for the purposes of adducing fresh or further evidence. Back at home, our own Benny JSC, then Benny J, gave a similar holding in the case of Compact vs. Lambien, 1989-91 Ghana Law Report, page 324, at page 326 as follows, quote, the general rule of evidence was that after a prisoner's case was closed, a judge should only call a fresh witness when a new matter had arisen as improviso, which could not have been foreseen. Such witness could, in a civil case, only be called with the consent of all parties. And although the evidence decree 1975 NRCD 323 permitted the court to call or recall witnesses, it was subject to the general rule. End of quote. Though the above definition made reference to the calling or recall of a witness by the trial court, the same principle applies where it is any of the parties who applies for such a call or recall after the close of their cases. One of the leading cases on application to reopen cases is the Canadian case of 671122 Ontario Limited versus Sagas Industries Canada Incorporation, 2001, SCC 59, 2 SCR 983. SCC, which was referred to as by counsel for second respondent. In that case, the court approved of a two-state test, which was first articulated in Scott versus Cook, 1970, OG number 14872OR769. That test, which is intended to assist the trial judge in exercising his or her discretion to reopen the trial, requires the applicant to show that the evidence he or she seeks to adduce is said that if it had been presented at trial, it would probably have changed the results. And two, prove that such evidence could not have been obtained by reasonable diligence before the trial. End of quote. This same test is what a party who intends to lead evidence or further evidence in the trial or on appeal must satisfy before a court could grant such a request. In the case of Poku versus Poku, 2007-2008, Supreme Court of Ghana Law Report 996 at page 998, which was cited by counsel for the second respondent, this court, per Wood CJ, expressed the principle succinctly in the following words, quote, the rule is intended to assist an applicant who has made a genuine attempt to look for the evidence and has met with failure. Courts ought to be adept at masking attempts by a dissatisfied party coming through the back door and under the cloak of having come by new or fresh evidence, seeking to fill in gaps or lapses in his or her case. For the rule is not meant to aid the slothful or the indolent, the careless, negligent, or reckless litigant, whether acting pro se or through counsel. The application is not granted on compassionate grounds. Neither is it meant to give the sloven, particularly a litigant acting through counsel and who fails at the trial to marshal his facts carefully or fails to conduct his case properly by presenting essential evidence at the trial or through the necessary cross-examination, or also fails to conduct the necessary investigations which would have thrown light on or strengthen his case or give him or her a second chance at rebuilding his or her case. End of quote. This same point was made in the case of Amabo vs. Obus.
Road size of around 80,000 kilometers. That's if you put together all roads under Ghana Highway Authority, under feeder roads, under urban roads.
And that which denies or grants permission to leave further evidence after the close of the case for the parties. In all the examples cited, the defendant did testify, and the plaintiff found the need to call for fresh or further evidence to buttress their case, though the courts, in almost all the instances, refused the applications. In the instant case, however, the respondent decided not to testify at all, so no situation arises for there to be the need for the petitioner to call further or fresh evidence to clarify anything, be it a doubt or a point raised in the testimony of the respondents, since there was none. The petitioner in his submissions made reference to Section 26 of the Evidence Act 1972, NRCD 75, NRCD 323, which he says operates as a stopper against the first respondent for failing or refusing to call a witness as contemplated by the filing of a witness statement. This section provides, quote, except as otherwise provided by law, including the rule of equity, when a party has, by that party's own statement, act or omission, intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon that belief, the truth of the thing shall be conclusively presumed against that party or the successors in interest of that party in proceedings between A, that party or the successors in interest of that party, and B, the relying person or successors in interest of that person. End of quote. We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumptions, is not applicable in this case in view of Order 38 Rule 3E5, Sub 5. The rules permit a party to call or not to call a witness who has filed a witness statement to testify, as the mere filing of a witness statement does not constitute an election to testify, as we rightly held in our ruling on the 11th of February 2021. Again, the petitioner did not decide to close his case after the testimony of his third witness just because the chairperson of the first respondent had filed a witness statement. This is because in law, a plaintiff or petitioner does not require evidence from his or her adversary in an adversarial system as ours to prove his or her case. The authorities are alleging that a plaintiff or petitioner succeeds on the strength of his or her own case, but not on the weakness of his or her adversary's case. Conclusion: we wish to reiterate that by settled practice and in the absence of express rules to that effect, a trial judge, just like this court, in this trial petition, has a wide discretion to reopen proceedings before a judgment is rendered. That discretion, however, one which should be exercised sparingly and with restraint, as motions to reopen necessarily involve a balancing of the accountability of counsel for decisions regarding the prosecution of his case and the interests of justice. Accordingly, in weighing the propriety of reopening proceedings to permit no additional evidence to be led or tendered, the court would typically consider the following broad questions. Would the evidence, if it had been presented during the trial, have had any influence on the result? 2. Could the evidence have been obtained before or during trial by the exercise of reasonable diligence? The court will also assess the relevance, necessity, and materiality of the proposed evidence, the effect, if any, the reopening may have on the expeditious conduct of the trial at large, and the importance of the integrity of the trial process, and finally, whether the other party will be prejudiced if the reopening is allowed or a miscarriage of justice perpetrated if it is not. As we've already indicated in this ruling supra, the petitioner in this application has not given us an inkling of the new or fresh evidence he wants to bring to the fore through the chairperson of the first respondent, and how that evidence could assist the court to do justice in the matters under consideration in this petition. Neither has he disclosed how that evidence will advance the course of his petition. For the above stated reasons, we find no merit whatsoever in the petitioner's application to reopen his case for the sole purpose of compelling his adversary's intended witness to testify through a subpoena without indicating the sort of evidence he intends to solicit from the said witness and how that evidence is going to help the court in resolving the dispute before us. We accordingly refuse the application and proceed without any hesitation to dismiss him.
As the court pleases. We are grateful to the court.
My lords, we are most grateful.
My lord, we have listened to your ruling and we will obtain a copy of it. I have to say, my lord, that we are struck by the fact that Section 72 of the Evidence Decree, or the Evidence Act, is not referred to, but Black's Law Dictionary is referred to. But in any case, my lords, I wish to notify your lordships that we have filed this morning, just this in the last half hour. So we have filed an application for review of your ruling of 11th February. And in connection with that, we are also filing an application for stay of proceedings pending the hearing of that review application. And no doubt the next steps in this case will be dependent on those applications.
Yeah, Councillor, excuse me. Please, has the registrar given you any date for the hearing of that application?
Not as far as I know. I believe
it is being filed.
It is being filed. I believe so, because this was about 20 minutes ago, and I don't think that the date has been given yet.
Okay. So we already indicated that this case has been adjourned to Thursday. So you will come on Thursday. Yes. If the motion is fixed for tomorrow, then we can come and take the motion. Yes. If it is for Thursday, you come and take the Thursday. But our orders still stand. So the court stands adjourned to Thursday. Please.
Order in court, please. Order. Order in court, please. Order in court, please.
I can hear you.
Okay, all right.
All rise.
with regards to roads in Western region and the Western North region.
Sorry, Honorable Minister, did you get the question? I didn't get it. I didn't get the question.
Yes, Mr. Chairman. Mr. Chairman, with the highest respect, I got the question.
Very well. Let me answer.
Yes, we all know, even from our elementary school geography studies, we know that Western region, has the highest rainfall pattern in our country. So it's true that a number of contractors find it difficult to work on road projects in that part of our country. But we are making effort to deal with that problem. But road construction itself requires a lot of water in some quantities, because even if you construct roads during the dry season, from time to time, in order to get good compaction, you still have to sprinkle water. That is why you see a lot of road tankers, water tankers during road construction, because it's a requirement in construction. Apart from the fact that, if the road runs through a town, it's also important to water it from time to time to retire dust. But it's the excessive rainfall that disturbs road construction. So for the time being, since nobody can do anything about nature, the strategy that has been adopted in my ministry and by government is that we are specifically targeting the Western region. And the honorable member, you are aware, because it happened in your own constituency, that instead of giving large contracts, which at times is normally the case, we try to share road jobs. We break them into what we call lots, so that if it's a 20-kilometer road, instead of giving it to one contractor, and there are contractors in this country that have capacity to do 20, 30, 40 kilometers of road at a time. But if it's in the Western region, you realize that we break that length into about 5 kilometers. And instead of one contractor doing 20 kilometers, we give it to about 4 contractors, so that they will be able to work faster on the roads there within the period that the region experiences dry season. And we are going to intensify that to ensure that we do a lot of roads in the region because of the heavy rainfall pattern there. Thank you, Mr. Chairman.
Yeah, Honorable, please. We agreed on one, but you were senior, so we allowed you to. Yes. All right. Yes, Honorable Sosi.
Thank you very much, Mr. Chairman. Honorable Road Minister, somewhere in February 2018, you had a tour of Medina Municipality where you announced that some 74,000 kilometers of road were to be constructed. That is in 2018, in February. I want to ask how many kilometers of roads were constructed between that time and the time you ended your office, and the cost associated with that. And if you can also tie that one into the reasons for the bad roads in Accra, and whether, as a policy, you are considering a deliberate, targeted policy at improving all bad roads in the capital city.
Thank you, Mr. Chairman. Mr. Chairman, I'm sorry, I did not get the first part of the question.
The first part of the question has to do with a statement you made in February 2018 when you came on a tour in the Medina municipality. You said your government was going to construct some 74,000 kilometers of roads, and that was on the agenda at the time you were doing that tour. My question is, how much of that were you able to do, and what is the cost associated with that by the time you ended your office?
Thank you very much, Mr. Chairman. I cannot recall that statement. What I know is that we were doing a number of kilometers of roads in Accra and Kumasi under the Sando Hydro project. Some of them included surface dressing, some of them included asphalt overlay. I cannot recall that I referred specifically to Medina alone for 75 or 74 kilometers of road. As I was talking about Accra road.
The chairperson of the Electoral Commission, Mrs. Jean Adukwe-Mensah, testify. And in our case, we wanted her to come in and testify as an adverse witness. Now, that is allowed under the rules, specifically Section 72 of the Evidence Act, allows a party whose interest is adverse to another party to call that party and treat that party as a hostile witness. Now, the strategy that we had adopted was basically to serve a subpoena on her, because as you recall, she had decided that she was not going to give testimony even after filing a witness statement. And we decided that we were going to call her by compelling her through a subpoena that would have been issued through the court system and served on her. But today, the Supreme Court gave a decision in which it basically said that Mrs. Jane Adukwe-Mensah will not be compelled, to testify. In our view, the court was wrong. In our view, the reasons of the court were based upon wrong legal premises. But the Supreme Court is the final decision maker when it comes to the law. And we have no reason not. We are bound by what it has said, this morning. We cannot depart, from it. But lead counsel for the petitioner has indicated that he is filing an application for review with respect to the earlier decision rendered on the 11th of February relating to their decision with respect to the compellability of the witness testimony of the Electoral Commission. Now, ladies and gentlemen of the press, the Supreme Court asked itself a question which we deem was a wrong question and answered that question. It said, why does the chairperson need to account to the people of Ghana when she's not a party to the suit? Now, you recall that counsel made it very clear that one of the reasons why we are in court
is because of the unconstitutional conduct of Mrs. Jane Aduke Mensah as the returning officer under the Constitution. And it is not true that there is only one issue that needs to be determined in this matter. I am surprised that the Supreme Court itself, having set down 5 key issues to be determined, is now reducing the issues to one, which is whether and the extent to which the evidence that we have led shows that no one got more than 50% of the votes in accordance with Article 63 of the Constitution. But we have made abundantly clear in the petition that there were a number of infractions. We are contesting even the constitutionality of the declaration that was made. We are saying that she violated Article 23 of the Constitution because she's an administrative, body. We have also said her exercise of discretion was contrary to Article 296 of the Constitution. These are all germane issues under the Constitution and laws of Ghana. And to reduce the petition into a single issue petition is rather unfortunate and smacks of a predetermined agenda to rule against the petitioner in this matter. The Supreme Court was called upon this morning to exercise discretionary power, judicial discretionary power with respect to whether we should reopen our case. Now, in doing so, the court was bound by the provisions of Article 296 of the Constitution, and we think that the reasons, as I've said, that the court gave are not acceptable. They are not tenable. The reason is simply because you cannot expect that we should have made our evidence, the evidence that we're going to present to the court, available ex ante or before the fact, so that the court will now determine whether or not this is evidence that will help the case. In any case, the petition and other pleadings filed before the court makes it clear, and any trained lawyer will know that the pleadings show very clearly the evidence that would be laid in order to be able, to prove the facts in issue. And so for the court to say that we were bound by law to make our evidence available for it to assess before allowing us to reopen our case is a legally problematic proposition. And therefore we disagree with the court. We think that the court, by this decision, has not done the people of this country a great service, in the sense that Ghanaians are interested in knowing the truth. Our Constitution is very clear that justice emanates from the people and must be exercised in the name of and for the welfare of the people. The justices today have not given us a reason to believe that they want the people of this country to know the truth about what happened, that they want the people of this country to be able to say why figures kept changing on the from the 9th of December till date. If you go to the website of the Electoral Commission, the figures have changed 5 times. Are we not worried as a nation that the returning officer appointed under the Constitution cannot even explain to us what happened? She made a declaration based upon a figure that she herself changed without recourse to the law. Is this something that we want public officers to be, engaging in? And secondly, she's a public officer. And as a public officer, she's accountable to the public. She's paid with taxpayers' money. Why is it that she cannot be called to testify? Why is she being treated as if she's a private person? Why is she being treated as, why does the court treat this important constitutional matter under Article 64 of the Constitution, something that could have been brought by an ordinary citizen of this country, as if it is a mere private matter, as if we are involved, as I said a few days ago, with a debt collection matter? This is not a debt collection matter. This is not a commercial litigation that we are engaging. And so we are highly disappointed with the decision of the court. Maybe the issues that we have raised today will feature in the review application that we have brought before the court.
The motion for stay.
And we are also filing a motion for stay of proceedings pending the hearing of our review application. So thank you very much if you have any questions.
Doc, at the risk of social media abuse, I have to ask, how much further, how much longer is your side going to go? For a number of applications now dismissed, the substance of the case itself, we haven't had a pronouncement on that yet, and so we cannot seek to say what would come out of it. But at these very press conferences, sometimes the comments that we get from your side suggest that you don't even believe in the ability of the court to determine or give an impartial judgment. I would reference a comment you just made that suggested that the ruling we had today was predetermined. How much further are you going to go?
Well, thank you very much. We are determined to go as far as the law allows us to go. And that is because we want the people of this country, the discerning citizens of this country, to see everything play out in the court, and that is the highest court of the land, and for us to be able to let everyone see that our resolve to pursue the truth is unrelenting. So we'll go to all the lengths allowed by law. As we have said, the Supreme Court has a review jurisdiction, and we are invoking that jurisdiction to take a second look at its own decision. And the review application will be filed with very solid legal arguments that we think should convince the court. If the court is not convinced, whatever options are left, we will pursue them. But we are doing this for the people of this country. His Excellency John Dramani Mahama brought this petition for the defense of the Constitution. He has a community of interest with the Constitution. And I want to make one thing abundantly clear. Sixtus, if you were the plaintiff in this matter, if you had sat in the comfort of your room and tallied all the figures, and if you were convinced that this matter, the declaration was in error, the Constitution allows you to bring an action. And your community of interest is with the Constitution, to defend the Constitution of this country. The judges have sworn an oath to defend the Constitution of this country. And so every constitutional issue that we think is germane and legitimate towards the resolution of this matter, we will raise until final judgment is given.
All right. Look, thank you very much. I stand corrected, but at the very heart of this petition is the fact that the petitioner claims that no candidate attained 50% plus of the total votes, or the valid votes, thank you. And the petitioner has come to court again, also asking the court to annul the results as were declared on the 9th.
Okay, yes, on the declaration.
On the declaration, yes. Okay. Now, my question is, so far, has the petitioner been able to prove that none of the candidates actually got more than 50%? If no, is it going to be through the cross-examination of the first respondents that will reveal that none of them had more than 50%? If no, then your case is dead now, is it?
Well, don't prejudge the case at the risk of being held for contempt. I would dare say that the case we have brought is very clear on the face of the petition. If you read the petition, it is very clear why we have brought this matter. Now, in respect of the figures, we made it abundantly clear from the beginning that these were figures compiled by and announced by the Electoral Commission. You remember that we wanted to inspect documents. Our request was not granted. You remember that we wanted her to answer interrogatories, which are allowed under Order 22 of the High Court Civil Procedure Rules. At first they said they were not applying CI 47, and subsequently they had to rely on CI 47 to save themselves. All right. They did not permit us to. They did not permit us to administer the interrogatories. These are all mechanisms allowed by law to elicit evidence. And I don't see why the petitioner in this case, or anybody filing a petition as a citizen of Ghana in this case, cannot obtain information from the person who conducted the election for purposes of proving that the declaration she made was unconstitutional because none of the candidates obtained more than 50% of the votes. And let me say this, you see, there is a tendency, and I think that that is where we have all gotten it wrong. Okay? I gave the example of Sixtus, you know, as an ordinary citizen mounting this challenge. Could the court have asked Sixtus to go to all the 275 constituencies and bring pink sheets? But read Article 64, Clause 1 of the Constitution. It says any citizen of Ghana may bring an action. So you can rely on the evidence compiled by and announced by the chairperson. In fact, in any jurisdiction, having seen situations of multiple summary sheets coming from regions, having seen situations of pardon, vote pardon, and admission of vote pardon by the respondents themselves, the court itself would have ordered an inquiry into the extent of vote pardon. And that would have not been based on our figures, it would have been based on the figures compiled by the Electoral Commission. And by the way, no party into an election produces figures. The official figures are produced and announced by the Electoral Commission of the Republic of Ghana. Why is the commission not throwing that evidence to all of us to say, look, here it is, this is what we did, now tell us why we were wrong? Why are they not doing that? And why is it that you as journalists are not asking that question of the Electoral Commission? You know, the notion that just because the principle of law is that, you know, he who alleges must prove, then it means that because the petitioner has come to court, he must produce the evidence by himself. Cross-examination is one way by which you can prove that burden. Why are they running away from cross-examination? Why are they running away from bringing evidence? And by the way, we filed a notice to admit facts. Okay? The law is that after 14 days, if you don't answer, if you don't admit, those facts are deemed in law to have been admitted. All right? So, in fairness to the petitioner, the facts enumerated, you know, for admission are deemed admitted. And let me say this. You see, they have decided they are not giving testimony. What is the legal consequence of that? It means that our petition and the evidence laid in proof of the petition stand unrebutted. That is the position of the law. And let anyone come and challenge me that that is not the position of the law. The court should have actually gone ahead to strike out their figures, their witness statements and their pleadings. Why is the court not doing that? That is a legitimate question that the petitioner is entitled to ask.
Just a quick one on the quest for Madame Jane Mensah to be cross-examined, testify and be cross-examined. The court in today's ruling said that you had not proved the relevance of testimony. Doc, you are shaking your head. Indulge me when maybe. You had not proved the relevance of her testimony to your case. It's one of the many things that was said in the ruling. I don't have the benefit of a written text. I just had to listen to it.
Yes.
And you have demonstrated, again, at a lot of these encounters, that there's a critical part of this case that is hinged on Madame Jean Mensah's testimony and her cross-examination. And it seems that is where we are now. She must enter the box at all costs, putting it, in a layman's terms. Let's assume Jean Mensah falls sick or takes ill tomorrow and cannot. What will be the direction of your case?
The court will adjourn until she's well enough to testify. that is said on a lighter note. But I think you may be going down the route of saying that, look, we haven't produced sufficient evidence to be able to discharge our burden. We think we have, all right? And again, the legal consequence of not testifying will have to kick in, all right, at this point in time. And I think that it is important that we highlight the fact that they have decided they are running away from giving evidence. And as journalists, I think you should be asking them more critical, questions than you are asking the petitioner. At the risk of being, petty, I think you are being unfair to the petitioner. You journalists are being unfair to the petitioner. You are not asking them critical questions. I mean, you file a witness statement. You represent it to the entire world that you are coming to give evidence. Why run away?
Let me
say this. Before you come in, you have, you saw the video in which Mr. McMenu said that they could also prove that, there was pardon in favor of John Mahama, right? Is the court not interested in that? McMenu basically admitted that there was wrongdoing by the Electoral Commission, but the wrongdoing affected both parties. Is the court not interested in that? So that Jean Mensah could come and then say why she parted votes in favor of the petitioner and parted some in favor of the respondent. And then also, let us see the extent to which the vote party helped one party or the other. Isn't that an important question that needs to be answered? And who best to answer the question than the person who declared the results?
Let me ask. Doc, just a quick follow-up. You made a point about the fact that, as it stands, your evidence has not been rebutted. Should that not be good news for you and allow for the case to proceed for a judgment to be delivered? And the second point, Doc, at the start of proceedings, we cited a letter that had been written asking for some additional arguments to be made. The court said it has noted that. Do you think that if you had the opportunity to perhaps address the court on that, it could have changed how things went? Then I realized that a larger chunk of your address this afternoon.
Now, Akable, you tend to ask double-barrel questions. Can I take them one after the other? All right. So, in the first, place, you are asking
about the evidence that you said. The evidence that you said has not been rebutted. So the question is, if it's not been rebutted, that should be good news for you. You should apply for them to strike out the issue that you said.
If we were interested in just legal technicalities, the court, is applying legal technicalities at this point in time. We are not interested in just the legal technicalities. We are also in pursuit of the truth. That is why we think it is important that she should testify. All right. In addition to what we have, the evidence we've laid, we think that if she testifies, Ghanaians will see that we didn't just come to this court making vain allegations without proof. We have laid evidence, sufficient evidence to show that there was vote pardon, sufficient evidence to show that there were, conflicting figures from, regions and constituencies and so on and so forth. All right. So we also made, it came out very clearly that the Form 13 that she said was a Form 13 wasn't a Form 13. Okay. And as I promised you yesterday that there will be very, salacious evidence coming out with respect to Form 13. And I told you that Form 13 is the reason why they are running away.
And Doc, is this evidence that was not available before you filed your case such that you could have put it through your own witnesses?
No. Okay, so, Form 13 was available to us. All right? But Form 13 wasn't put in our, I mean, we didn't put Form 13 in. Form 13 was put in the witness statement of the electoral, of the first respondent. Now, Akable, you do remember that there was an attempt to put that form into the evidence through Dr. Michael Pesa-White, and we resisted it. And then it was Justice Gertrude Tokunu who still pressed, and the form was shown to Pesa-White. And you heard what Pesa-White said. When he said it, the court went very quiet. All right? He said, this is not the Form 13. That the Form 13 as spelled out in CI 127 is different from this one. Was counsel, my good friend Mr. Justin Amenivo, not in court? Why didn't he protest? And why didn't he, get up to show to the court that the Form 13 they had presented was the same as the Form 13 in 127?
Doc, finally, I was asking about the letter and the fact that you were
the court, we thought that, if we cited those authorities, it will assist the court, okay, because it's a court of law and a court of justice. And therefore, the issue, you remember that the issue was raised very late at the proceedings yesterday, when Justice Mafusau basically said that there was a judicial bar, because Jane Mensah was not, she was a party to the proceedings. And we said, no, she's distinguishable from the Electoral Commission. All right? There was no time for us to be able to address the court sufficiently on the matter. But upon further research, we decided that we were going to cite these authorities to the court to assist the court in coming to a tenable legal conclusion. Unfortunately, the court took the letter, but decided to treat it with contempt.
So Doc, is it your contention that if the Supreme Court goes ahead based on the evidence that the petitioner has put forward to determine this matter without hearing from the respondents, it will be a miscarriage of justice?
No, can you ask the question again?
No, I'm asking that, are you saying from your arguments that if the Supreme Court goes ahead to determine this case, this petition that is before it, without hearing from the respondents, it will amount to miscarriage of justice?
Well, not necessarily, but justice demands that the truth be told. And that is why we are in pursuit of the truth.
All sides are fair. Doc,
okay.
Doc, you indicated that the truth demands that justice be told. In this
justice
case,
be done.
Justice be done. In this case, it looks like justice for you is for the EC chair and the returning officer to answer some questions. It's so clear that it's not going to happen. There are people within your party.
You know the outcome
so
of
far,
our review application?
So far, it's clear.
No, you know the outcome of the review application. Are you predicting?
So far, it's clear it's not going to happen.
You see,
and with your comment that you believe that some of these rulings have been predetermined, people within your party are asking you to withdraw this particular case. There are a number of people within your party who say, look, this thing will not end us anywhere. Just withdraw it. Would you do that?
You see, when it gets to a point in time that ordinary citizens, lay people, can predict court rulings, all right, I leave the justice or fairness of otherwise of the rulings to your judgment.
I think this will be the final question. Sam is very scotchy.
Okay. And you're back court no, at seven sea court no, akoye arehusem kakra. It's saying say Jane Mensah or ye Electoral Commission ni game trainer abatra 2 yi na gina ne so no. Ye ba ne se enka court man ho kwan. Na nko omegina daka no. Na nsem bebre amanfo bisa no watimi ya no. Ankobanisa court say oni ye nyadwen nti nanso biom akwakoye 70 me no wokasei almost say woman mahu kwai ma Mensa emma adakanum na ne awo ho sem ne say ye mra ye adwuma o Ghana ha no evidence act no section 72 mahu kwai se obi a woni no kura nya adwe no kura wutumi fe no obeda no wadanse enne ye mra no mom eda nchen enne yakofa abrochie mra bibira be hihye mu a yedi aka asem enne ne hunya pass obi abehu ni se yen as petitioners no ya dwumpo ina ni se ye bedi nukura na chia kosisi ensa beka nukura no ensa ensa se ye pe nukura hunu a nukura ni ina ni se Mensa eba be gina de kanum na ni esi ya nkasa no waka ensa se wotwa nsem ni bia ka ya for example ye say ye di abanu bi keka ho vote pardon aya makmenu a kasama na ekufuado wabeji atum se ayampa ye di abanu bi keka ho why na di abanu keka ho ye Mensa nkwa ne betime yi ano se wiye nu nsufi wa je Mensa nkasa ba be ka kire ense waye mistakes bebre e wonu na asemu na adenti na waye mistakes na anabe gina de kanum na kire ye from 30 a use form wa yedi e ka asem na nkata no wa use form a what yedi use anya no nso na we use ye uko use form foforo enti ye na me no kase ye results baku enum a ye nim results ko a yedi edwuma Ghana enti se sana tie na nia ogina mu oyaba no ye se bra begina betima na wo se unma why na betima be kire mu why na betima be kire nsem na sie no we na sie why na betima kire mu na e wa kakra se Supreme Court baby Supreme Court dinano nanka I was say Supreme Court ka say me na say accountability ni yemfa evidence maye ade omo ma dia tum say mistakes adia magmenu angasa say dia ade no bi keka ho enti ade ntina o twanti for evidence bembi na baba kire say ya ade no bi aka ho evidence na kire say ya di den yemfa ne say go bi fufu bi kura na nya John Mahama no petition ya angasa na baka jonkonko fa na results mrana ya results ya de ba court no eye nia o man no mra ama no ho kwan so on fa results mra ono ne Mensa wa bana se problem we wa ono kwa ni results na so ba be kiretim onu ni agina so se omra no nkire mu baako eye den and mistakes ye hu na ye hu ye be say me chemo boss ye as petitioners ni de ye be die kire obi bisa say adenti na ye withdraw ni enkotra da bi ya amasi ye be say wi ni kwa o ye ba nso say Ghana fo na be hu no kura wa asemi mu esan say John Mahama odo no wa ba for say obi be hu no kura wa asemi na wo utifi a utie mi no wo hu ni say abato na etu no kura enie e ba ni say mistake ba ha and a mistake amba ha aba sa na nie ye ba court no ne asaka ye nsa ba ye ba court na no kura grab ya eno ani ade epe no kura enti ne yo ha ye da mo say
But if there are more questions and people want to ask questions, they should have a right to ask the questions. We can't stop them from asking their questions. Colleagues, good afternoon. We want to start by reacting to a number of comments that have been made by the spokespersons for the petitioners' legal team, and then we will deal with our summary of what has happened. I'm sure you have all followed, and so we don't need to even spend so much time on that one. Our colleagues who speak for the petitioner started off by telling you this afternoon that they are of the view that the Supreme Court of the Republic of Ghana is wrong in law, at the ruling that it has delivered this morning. They also claim that the Supreme Court has reduced the petition to a single issue petition, and that smacks of a predetermined agenda. I'm sure you heard the words used by Dr. Ayine, that the Supreme Court has reduced the petition to a single issue petition, and that smacks of a predetermined agenda, ostensibly not to rule in favor of the petitioner. Now, we want to deal with those first two while dealing with a third matter. They keep bandying this word about truth. What is the truth? And that the truth must be allowed to come out. We'll deal with the question of truth as they talk about it. And then this claim that the Supreme Court is shielding the EC chair from getting into the box. In fact, in Chi, they make the argument that the Supreme Court doesn't want to allow the EC chair to give testimony. We'll deal with all of those before we come to our submissions. And then they make the argument that they are doing this for the people of Ghana and in the defense of the Constitution. We honestly don't think that is true. We'll deal with that one. First, let's deal with the issue of the court being wrong in law. This is the Supreme Court of the Republic of Ghana, a bench of 7 justices. And I think on about 2 occasions, 2 others have come to join them to review some of the applications before them. Except for the application for leave to amend the original petition, it is true that all the applications that have come before this court have fallen flat. But how can it be that the petitioner's communication team now argues that the 7 justices or the 9 justices are always wrong in law, and only Mr. Chachuchi Kata is the one who understands the law, knows the law, and is therefore always right? It cannot be. The last time they won some arguments that some of their paragraphs of Mr. Rojo Metununu's witness statement should not be struck out, you heard them right before you that it was a monumental victory. Are those not the words that they used? And we keep making the point that it is not fair to the judicial system, it's not fair to our democracy, it's not fair to the people of Ghana that when you lose an application because it is not grounded in law or because you have failed to meet the legal standards, then you come here and literally poison the minds of the public and make claims that they may be having a predetermined agenda. That's scandalous of the courts. It's scandalous of the courts. When you make a legal argument and it is upheld, that one is good. When you make an argument and it doesn't meet the threshold, then it means that they are wrong in law or that they have a predetermined agenda. The Supreme Court has not reduced the petition to a single issue. We tried our best to transcribe the ruling. We are waiting for the written version of it. The court said that the major issue, it didn't say there was a single issue before it. It said the major issue. And time again, colleagues, we have read out to you the 5 issues that the court is seeking to determine. And the court says that the major one, and I believe in the minds of every well-meaning Ghanaian who has been following, and I indeed heard it from your questions, the major issue, you forget what they said earlier that they had won. The major issue they brought to court was that nobody had crossed the 50% threshold. And everybody's been looking forward to them adducing evidence to prove this. They have been trying in the last 1.5 weeks to shift it to a new constitutional accountability argument. And the court reminded us the last time that you came here under Article 64(1). The court today has said that the major issue, why do you then decide to mislead the public that the court has reduced the petition to a single issue petition? I think it is very unfortunate, and we must start off by correcting some of these issues. Now, they talk about the truth, and that the truth must come out. The truth must come out. What is the truth? The truth is what the EC chair has declared as at now, that Nana Addo Dankwa Akufo-Addo validly elected because he got more than 50% of valid votes cast. The truth is what is backed by the results of the 38,000 polling stations, or the 275 constituencies, or the 16 regions, which anytime we give them a calculator to calculate, they get 47% for Mr. John Dramani Mahama, 51.2% for Nana Addo Dankwa Akufo-Addo. That is the truth. If you come to court claiming that there is another truth, you have to lay it before the court. So where is the truth that you say you want to lay before the court? You remember when the court asked them, they said they had left their truth at home. They did not bring their truth to court. So which truth is the court supposed to look at? The presumption of regularity is before the court, and you say there's another truth. Where is it? And you say you won't bring it, and that the EC chair must be compelled to get into the box so that you can conduct some surgery and explore the truth out of her. We are not being fair to the people of Ghana if we continue to change the goalpost at every hearing. Now, they continue to make this argument that the Supreme Court is shielding the EC chair or preventing her from getting into the box. The court has said over and over again, and we hope that our colleagues on the other side will pay attention to what the court is saying. The court has said that you cannot compel her to get into the box. She will elect. Indeed, your own argument earlier was that she had elected to get into the box. And the court, after listening to the argument, showed that no election had taken place. So that argument falls flat on its face. Why do you now come and tell the people of Ghana that the Supreme Court is shielding her and preventing her from getting into the box? Because she is somebody or a party who you have brought to court. And the rules settled from the beginning that you cannot compel her. Whether you come by subpoena or you come by any other instrument, you cannot compel her. This argument, therefore, that the Supreme Court is shielding her is one that, again, our colleagues in the media, I think you have to be very quick to call out and let the public know is not true. That is not what has happened. They are the ones who objected to the closure of the case of the first respondent without putting her in the box. They objected. Why? Because they said she owes constitutional accountability. And the court has said that you haven't provided any authority or any law to show us that she should be treated with a different set of rules. Why do you misinterpret that to the public, that the court is shielding her? We think that these things should be called out. Now, there are two paragraphs in the affidavits that were before the court today that I want to read out to you. And I beg you to pay attention to this. This is the affidavit of Mr. John Dramani Mahama in support of the motion to reopen his case. Remember, we kept saying to you in the beginning that it was becoming obvious that they have not succeeded in making any case before the court. And that what they have put together before the court, 30 out of 35 paragraphs, are complaints about the declaration. It doesn't attack the validity of the election or the validity of the results whatsoever. And they said what we were saying was not correct. And we said, bring your witnesses to come and prove it. 3 witnesses they brought could not prove it. And when the Supreme Court heard them announce that they have closed their case, and the first respondent said, I will not get into the box to adduce any further evidence. Determine this matter on the evidence that they have brought before you. And we said same. They objected and said they wanted to bring her in. The court ruled on the 11th of February, the law does not support that position. Then they have come with an application to reopen their case. Now listen to paragraph 20 of that application and that affidavit supporting the application. It says that this witness has a unique role under the Constitution in respect of the presidential election that took place in Ghana on the 7th of December 2020. And having her testify is critical to this court. What Mr. Mahama and his lawyers are telling the court that they themselves don't believe that they have made a case before this court, and that if this EC chair is not compelled to get into the box, their case is collapsing. That is what they are admitting by paragraph 20 of their own affidavit, Mr. Mahama's application, Mr. Mahama's affidavit to support the application that they made. That if this witness does not get into the box, or if this person, this party, is not compelled, dragged into the box to testify for them, they have not succeeded. But if you've made a case, why are you begging the court, going up and down, misleading the public that if this person is not brought into the court, you cannot make a case? I thought they said initially they had won, or that nobody won, and that they had 5 witnesses who are going to prove it. They are now telling the court that if the court does not compel Jean Mensah to give evidence on their behalf, and yesterday you heard that they want to call her as their witness, and they will treat her as an adverse witness. And by the way, the court explained today that that argument is not sustainable in law. It falls flat on its face. There's no legal position to back it. They are now saying that if she is not compelled, they can't make a case. Now, when yesterday, the learned Akoto Ampao, in paragraph 12 of the affidavit supporting our position, said that the instant application does not raise any new matter of relevance which could not have been discovered by diligent effort and does not warrant the grant of leave to petitioner to reopen his case. They said this was irrelevant. And today you heard the court essentially going back to these arguments and the authorities that we had raised to come to a ruling that the position of the law is settled that you cannot compel a party to get into the box to testify. So it is not about truth, some truth which you say you have left at home, and you are asking the court to drag the EC chair into the box so that you can conduct some surgery on her and find the truth out of her. It is about a legal argument of whether or not she can be compelled into the box to give evidence. And indeed, if you have some truth, why don't you lay it before the court? Now, colleagues, we heard you argue that, or we heard you question, that now some of their own supporters are saying that perhaps they should withdraw at this point. And indeed, it is our view that Dr. Ayine skirted around the issue, didn't respond to the question. Says he leaves it to the judgment or the conscience of people. Why are NDC supporters now saying they should withdraw? Because they are observing before their very eyes, as this thing is televised live on TV, that their petitioner and their lawyers are not making a convincing case before the court. What they told them is not true. And that is why now they are asking the court to reopen their case so that they can put a party on the other side in the box and compel her to testify to make their case. It's becoming clear right before your very eyes that this is the reason for which their own supporters are telling them that it is about time that they abandon their case. But we want to conclude by dealing with this argument they make that they are doing this for the people of Ghana and they are doing this in defense of the Constitution. We vehemently disagree. What they are doing, this so-called petition before the court, is not for the people of Ghana or in defense of the Constitution. It is for the political interest of Mr. John Dramani Mahama, who desires this media spectacle to sustain his brand equity and run again unopposed in the NDC in 2024. Let's be honest about it. It's not in defense of any constitution, because if it was, the Constitution says that our legal system is adversarial, and therefore you can't compel a party in the box. Why would you be claiming you are defending the Constitution and asking the Supreme Court to turn the Constitution upside down? Those arguments don't hold the test of time. Today, the court has reaffirmed the decision it made on the 11th of February, that you cannot masquerade the same application in a different dress and expect it to do that which the law does not allow it to do. We'll take your questions.
Right. Honorable, good afternoon.
Good afternoon.
So, on several occasions, whilst addressing us, you have referred to the fact that the petitioner also appears to be panning towards public opinion and saying things out of court just to win public sympathy. Unless the second respondent doesn't believe that public opinion is important, I'd like to find out from you. First of all, there was an application for interrogatories. It was dismissed. In the public opinion, it was the fact that the EC, the second respondent, the first respondent, I beg your pardon, has something to hide. Then there was another application to allow the petitioner to inspect some documents. Again, your counsel opposed to that. What went out in the public domain was that there was something to hide, and that is why you were opposed to it. Now there's a refusal to present witnesses.
A refusal to compel.
Well, first of all, your side said you chose not to present the witnesses. Again, the opinion out there is that then it means there is something to hide. If there is nothing to hide, and if the public opinion is also that important, why don't you just open up?
Why do you not? Well, we have said over and over again that this is a court of law, not the court of public opinion. What our colleagues on the other side do is that they come to court and they make arguments that, according to the Supreme Court, these are not my words, according to the Supreme Court, are not backed by law. The Supreme Court has said on about 3 occasions that we don't know any law that supports what you are telling us. In fact, 2 days ago, they asked that this application you have brought, what's the legal basis? So we are praying to the inherent jurisdiction of the Supreme Court. There are times when they cite cases, Elistamaklo, the court says it doesn't apply. Several times they end up speaking at length, and the court says that the law doesn't support the grammar you are speaking. These are not my words. It's the position of the court. Then they come here and they spin the story to create a different public opinion, that the interrogatories are not being up. And you heard Dr. Ayine repeatedly say that the interrogatories were not allowed because the court claimed that CI 47 doesn't apply. We challenge him. The court never said that. Get a copy of the certified ruling and read it. The court has never said CI 47 doesn't apply. The Supreme Court holds all the powers of the courts beneath up to the Supreme Court and has been using CI 47. CI 99 applies to the procedure in here, but some of the basic powers in CI 47 or as amended 87, etc., they all apply. And the Supreme Court in using CI 47 said to allow interrogatories, they must be relevant. The question is a question of relevancy. If you come and you ask irrelevant questions painted as interrogatories, the court will not say that just because interrogatories are allowed, it should grant you those when the questions hidden in that box are irrelevant. And you heard His Lordship the Chief Justice said that this your application falls flat on the grounds of relevancy. So if you come and you poison the public mind that they didn't allow it because they have something to hide, you are not talking law, you are talking propaganda. If you come and you say if they have nothing to hide, why are they not allowing us to inspect the documents? You are not talking law, you are talking propaganda. Because to be granted leave to inspect, you must meet a certain legal... But why don't you want to meet the legal standards? Why don't you want to make a convincing legal argument? Do research, back it with authorities. You heard us yesterday, quote authority of authority, Poku versus Poku, Berima, all of these ones quoted. Today you heard the court even adducing some of those to back it. You don't want to come with arguments and legal basis and with propaganda arguments to the public. Why do you want to tell the public that somebody can be compelled? When indeed that's not the position of the law. These are not my words. This is what the Supreme Court is saying. So the court of public opinion matters. But you, our colleagues in the media, we won't fight with you. We won't say you are not being fair to us or argue with you like that. In fact, we apologize on their behalf to you for what they did. But you have a responsibility to help educate the Ghanaian public that what the people are saying is not law, it's grammar and propaganda. Because there are legal standards that must be met. And the court has been, in fact today, let me just go on one small tangent. If you notice, the court for the first time set out the parameters for determining when you can grant leave to reopen case at the Supreme Court. Any impact on results, obtainable by due diligence, the materiality question, importance of integrity of the process, prejudice, miscarriage of justice. They have laid down about 4 or 5 principles today before you and I this afternoon. This is law, not grammar. So when courts below are now looking at this matter, this is what they will apply to. We pray you to also take an opportunity to help us educate the public so that people don't go telling them stories. Because if that was the case, we have hinted you twice or thrice that, listen, if an argument can be made for a party to be compelled, i.e. the EC can be compelled, then it means that John Mahama can be compelled. Not so. So we should stop the legal work and now make an argument that, okay, we are come to compel John Mahama, we are come to compel John Mahama. We provoke thinking by throwing some of these things out. But just to answer your question, the court of public opinion matters, but you have to help us to educate the public so that people don't throw propaganda out there. Yes, sir.
What does it hurt, whether in law or in the court of public opinion, if the returning officer for the December 2020 presidential election, Madam Jean Mensah, takes the stand? Again, we still are not clear what direction the court is going to go on Thursday. So question is whether you are still going ahead to file your addresses or you are waiting on the new processes that we have just been notified of to see how that goes.
Sisters, I'll deal with the second one first and I'll come to the first question. So you heard at the end of the proceedings today, Mr. Chikata announced that they will be applying for 2 reviews. The review of the February 11 decision and the review of this decision as delivered. And that they have filed, initially that's what he said, they have filed in the last, he said in the last 20 minutes or half hour. And the bench asked, have you filed or you are filing? And then later he changed, he said, we are in the process of filing. I believe it should have been filed by now. Indeed, for those of you who are in court, when the bench sat and started reading out the decision of the court, then one of their lawyers with the documents got out, even before the ruling was completed. You saw it in court. And you can tell your viewers and listeners whether what I'm saying is true or not. Stepped out to go and start filing the process.
We saw somebody walk out of the courtroom. We don't know where the person went.
He's the one who went to file it. It's a matter of public record. But here's the point. The exchanges between the bench and the bar was to the effect that, so what happens to the submission of addresses on Thursday, and His Lordship the Chief Justice says that our orders still stand. So those orders we understand that we should respect. And he said that if the court is seized with it and the registrar has given a date for it to be heard before then, this court will come back and hear it. And we'll be here also to make our views known on that. Your first question was about what does it hurt? It turns the Constitution of Ghana upside down. It turns the adversarial system of law, which is in our Constitution, upside down. It compromises the time-tested, laid-down procedure for adjudication in our courts, which is that when you allege, you prove. That when you tell the court that you have closed your case, you must have some extraordinary circumstances to demonstrate to the court before it will grant leave for it to be reopened. When you don't do that, you don't come, excuse my point, with the propaganda argument of, oh, but what does it hurt? It hurts the Constitution, it hurts the law, it hurts justice. We are here for justice. We are here defending every single vote that the 13 million people cast. Those who voted for Nana Akufo-Addo and those who voted against Nana Akufo-Addo. We are defending all of those votes. If you say that those numbers are not correct, why don't you want to take the responsibility to come to the court and say, these are the numbers that show that this one is not correct? And you say that it is critical to compel the Mensah to get into the box so that you can make him the case, or you can make your case. In 2013, Dr. Farijan entered the box, not because he was compelled by subpoena. Dr. Farijan entered the box because the brilliance of Alhaji Dr. Mahmoud Baumia in demonstrating 11,000 pink sheets and the problems with it compelled Dr. Farijan that if he did not get into the box, the job that he had done was going to be set aside. There's a major difference between these two cases.
So you're giving us a duty to go and educate the public that this is a court of law and not, for grammar. Now, the ruling of the court today would mean to say somebody who just voted, a first-time voter, that the chairperson has, answered questions on behalf of the commission. And
sorry, I'm sorry, I can't hear you. Well, you're saying that the ruling of the court today is
that... It suggests to say that once Madam Jean Mensah answered in the response, then it means that the commission has answered. So the understanding they are going to get is that Jean Mensah is the Electoral Commission.
Go ahead, I'm listening.
And so in that case, how then do I go and convince somebody who just voted for the first time that this is, the court is not shielding the chairperson of the Electoral Commission, but rather is making sure that the vote they cast is protected?
Because somebody came to court with an application that the numbers or the declaration that I hereby declare that Nana Danko Akufo-Addo was validly elected and is therefore president-elect. Somebody came to court saying that declaration is not correct. That person is refusing to give evidence to prove it. He's brought 3 witnesses, and now he's saying that his witnesses didn't do a good enough job. And until they drag the EC box into the chair, he can't make his case. And the court is saying that that flies against the Constitution, it flies against the adversarial system, it flies against the system of law we practice in this country. It has nothing to do with the EC chair answering questions. If you want the EC chair to answer questions, we can invite her to Parliament. There's a whole constitutional provision for parliamentary inquiry. But the forum that you have chosen and the constitutional provision you have invoked, Article 64(1), is not the platform for general constitutional accountability. Are there any questions, my colleagues? Thank you very much. Abushanfo ni adehia anemwo ha yebeda mo ase enenso eyeda etoso edunsia yehia ewo ha na ansa na no metre sene da ya ne mo ye adwuma no efe adwuma ansantwofo mo ye ne eye enti mi nso magina afidie so na mapa mwacho ye nuanum NDC fo omo nsam e no mo kasa tietia mo ne ntokọ mo ne mo ko mubusa asema na akwese abufuo na nsam mo kana akwese kasa twitwe ne mesre ye ne mo na ye adwuma yi enti no mamo mfa eye hwansena ho ahi na mo kwabre mu kuro ya pa chewa ma yenuanum NDC fo mo kasa na munye hwam na munye kra na yesai atwa so biema ene asema ye ba wo hase no ehu behia opani Dr. Ayene Mr. Kasa eno be kasa ye e kam yakwa se ye ka nyegu eye Supreme Court mpanifo hu fi no enye ehu nya ye pa sanse wode wasam eba Supreme Court a gidia wo nyina ne se ahwene te wo mpani animu a ebi yira
It is a wood was ember penny penny can some nasa babontin. Now with the cassette cassa munya de cassa huntie. Now with the banal casse. No crack gun for person muno. I am penifoi almost Supreme Court episode on Mocassa. A cassa and yet. A cassa a book or tenantia. And to Doctor Ian Messer, the bill will be a Missouri on patrol. And your cassa, a your cry now, so can be say. And the Supreme Court is someone will cry and also. And ma pay your attention here. Almost in the trassy. Namrano Oma fa and Madum Ranicoma. And your cassa and your papa. Not be a Massa Cassa and your Supreme Court in Penifoi. Almost assign. I share a year, Madame Jane Mensanchi, and no more Kencity, and I answer Omon Peso Becassa. And your Cassa Efra. Abusia Sanka, ye can't be pank, nay, or Sanka. Jumedia, ye do Supreme Court. On fun and Ibraso Nanka on funnel. Say, ya someone who here. Simple, Yasio Penny Mahama. Court or by Obama Ghana for. And so ye shall court them and Predunsia. Emu mienu penwaba emu du nan no omaye nanso no ono yenka se ana yenka bibia mfentia no asambe na aba abusuafo asama aba ne se Ghana ha ye mra ne kire wa obokwa edu no ona ade ho dansidie ba ye Evidence Act section 1417 ekire ana wo konso anya dansidie keke adansidie mu oduo etisa wo court na obo nkro wie wo kan wa asem nyina wie na wa wo de to court anim say won sam a waka no wani age hu ye pa enti no wasem no wabo nkura wie watopunum na court so de na no asem atoso na court na no asem to so wie na anoyifo no so aye respondent no omo so de omo no asem aba na wei adansifo amofra omo ne nsem a mo kan wo court nyina no na ensisi so na enyina mra so na nya nsem a wose aye anoyifo no omsai omadaje enuti ensamo a court kan ne se sempo upesa wodi ahoma eso aye maami Jane Mensa kon na obegina adakam na wodi adanse a emra ne nkyesa yeni mra nso a yedidi me masem ene yedidi wo wasem ana mra foforo nso a yedidi maami Jane Mensa asem emra ne ye ba kope na Ghana ha mra bia ne ho abetimi ahye obi so omegina adakam na oni ho adanse ana wakwa akofa dan no epono na chi ana wo sai abasa wo case a wan kasa wo de wano enye obi na kan no wo close wo case na wo se wodi wa agro nyina awie wa bo nkura awie no wo sa se court makwan na bie wa asem no na de kronti a wo bie wa asem ne se wo pese court e de enhye ehye Madam Jane Mensa no begina dakam na toto na no court na asem o kan se ansa na obebi asem ani no na bia okuta dansidi bia dansidi na bra na wudi asem no ne yenya nhuye enye no nko a empokra dansi nie no na ewo sa ukire mu se eyampa eyade na wo hwehwe na woni abre se wo hwe sa dansi na won sanka na afi na won saka anya no nko a o sa dansi die ni adansi die mu odu a ebetimi asakira eya asem na ye dinani dabi we die ensem mo de ba court no anya dansi die fufuru bia na embom asem mo kan se yemi asem nani na omuntimi santwe Madam Jane Mensa emba begina eye court anim eno na court ka say emra no enkyere saa na nya de obetimi aye nempo eno na ye gina he ye sa kan asem ba ko say Justice Olenu kan say bi say obi bia obekọ court a obegina obi asem so say wo de nipa no beka na asem ansa na wasem mo ayedu no na say nipa no na bia na wutrim ekaw enye me na me kan ye eye opani Jamfi versus Bedu ena ebiem Poku versus Poku eno so Supreme Court asem a say enye obi bia oye kwadwofo wa wo mpa adwuma wa wo no unwura mu ndomo asukọ se ne amra ne ka no na emu ba court wani ha na wo ba na no o se court ne mo da bi court no enya ade a court be saa eti court anu asema o de ba ye no ene se emra bia ne ho no ma be hye Maami Jane Mensa se o ma be gina dakam na ya tete nsem ne bia nkofo ka se papa yonti sa asem no be da ho nti ka Maami Jane Mensa oba na nko be gina dakam ana ye dey abusuafo ensama oba pa Jane Mensa so kan nyina ne nyina na wo ho okọ abafu mfidie so a yisi ewo ho ne nkrata odi aba court ewo ho ade kronti a Maami Jane Mensa wan nyina dakam ni se ye nuanom NDC fo ne petition no ɔmantimi amfa adanse a ɛka fam a ɛfɔ mpae ama court. In fact, and someone back out court nyina no and my yaya sama yɛka no koraa no ahyɛ mu kina yaya sama yɛka no koraa ma mo yɛdu enti nsɛm a yɛka nyina ne sɛ ɔmu ni asɛm wobɛka ya ne yɛdi kan amane sɛ nsɛm no koraa no nka court ni kan mongu ɛna court sɛ da bi yɛde bɛka nsɛm a ɛyɛ botae a ɛno nti ɛba ha sɛ no ho ne yɛdi afra enti yɛ koraa ne yɛdi kan ato nkra dada sɛ mo nsɛm a mode aba court no ɛmu ɔha ɛmu nyɛ du enti abusua and then somewhere kosi yɛ no ne nyina gyina mmara so na yɛba court a sɛbi ɛnyɛ nkurobɔ ne yɛba bɛbɔ o ɛna ɛnyɛ agodie ne yɛba bɛdi ɛyɛ mmara enti na yɛba ha sei ade bia yɛyɛ wɔ ha bia no ɛyɛ mmara enti ne yɛwɔ ha o ba afa adanseɛ bra mɛma na sɛ mmerɛyɔ ɛwɔ wo wasɛm mu a wopɛ sɛ wogyina obi so ɛna de yɛ wo wasɛm dabi ɛno ɛnya ade a court ɛbɛpene ama saa asɛm no akɔ so abusuafo nyame yɛ adom a ɔkyena anaasɛ na de kyeɛ yɛbɛsɛ ahyia na wohwɛ nsɛm a court ɛbɔ ne tɔfa no nyinaa no a ne ɔmo ka nyinaa ne sɛ ɛnya adeɛ a court ɛbɛtumi ama kwan ama madam gye mensa aba bɛgyina ho na sɛntwerɛfoɔ busa asɛm bi na ɛmu yɛ mede paa san sɛ ndc foɔ bi ɛka sɛ ɔmo withdraw ɔmo case ɛnokorɛ sɛ ndc foɔ kasa a ɔmo di ka because wonya witness na ɔbɛtena daka mu no kase krata ode ne nsa hye ase no ɛyɛ opani rojo metonunu krata no mfomso no ɔyɛyɛ na ec chair ne dada no wɔsi ec chair ɛsake no ɛpamo no ɛnso na adanse aba bɛda di sɛ wokɔnom tea na biscuit ne amfa ama wo ne nyinaa no yɛ nneɛma a ɛbɛda di enti ndc fo kɔm mfa wo serious opani kwasa white ebusa na wo si nipa aba bɛdi dwumadi kɛse sɛ wo si wo free fie aba no wo refi wo charger wo fie enti wo phone bedum ye enti nipa a wo pay figures na free no wo constituency regional level no nipa ne pɛ sɛ ɔfrɛ wa nkomo bɛ no betimi wadi enti ye nuanu ndc fo kɔm apa aba ɛwɔ asɛm ne mu ɛno nti no ɛna ɔmo ka twa ɔmo nkɔfo sɛ asɛm na bɛyɛ kwan ka mo free court because mo amo nkɔfo mbɛdi adanse kra no adanse di ɔmbɛdi ye no emu ɛha opani asie dum katia obɛtena da kamia mane bu nkontana na nkontana kwakosi sɛ na nado danko akufo adunya ɔha mu nchichemu aduonu ne ɛkyerɛ yi nkota bi obu ye bia no ɛkyerɛ saa enti esi dan ɛnɛnɛ mo sa ba ɛbɛka kyerɛ sɛ agye sɛ mo case ne nyenti no mo de ahyɛ mo krata mu sɛ ɛhu behia paa ma mo case sɛ na bɛyɛ mo case mo bɛdu agye sɛ mo a megye mensa ma begina daka mu abusuafo yenuanom ndc for any petitioners no omasem nankasa no omadwen mu omato agu enso bi eni agina mu nyame ya adomo a yebeba court biem court ahyese obi amfa ne closing addresses aye wie no obi amfa na asem ngu krata so ne ensan emfamra nyame nhyira mo ndc case ne de atonsuom na senia dame ya no mesre mo chairman makmenu aka yen chen e wa hase aka yen ho star witness on ejin mo mampani na nado danko akufuado mame lawyer Joyce Opoku Boateng so ha say lawyer Faisal e ha lawyer Lennon enso e ha eye Hajia Fatimatu Abubakar eye lawyer papa ono so ha minister in charge of information designate ono amunso SI eye lawyer Evans Nimakon on in charge of elections ono nkuntabu e course ba nyina no ono na di animu lawyer Keyamo a me say lawyer Ashon
the thickness of the asphalt, is very minimal, and it will reduce the cost. So when we talk about costing of roads, you don't take it, at its face value, because 1 kilometer of road, even if it's for surface dressing, could